Hi there. This is Dan Daniels. I want to welcome you to this podcast on typical estate planning for married couples. A well-drawn estate plan will address any number of questions, but among the most important are those shown on the slide. Where do you want your assets to go? Who do you want to manage them? One of the hardest decisions you'll have to make in the planning process is who should be the trustee. And if you have minor children, who will take care of them? Who will be their guardian? If you have trusts under your plan, and it's highly likely that you will, what will the terms of those trusts be? How do we plan to minimize estate taxes? How do we plan to avoid probate? And what about incapacity? Minimizing estate taxes is probably the most complex of the things that we do in the planning process, so I'm going to talk about that first. The primary tax we're concerned with is the federal estate tax. This is a tax that applies to everything you own when you die. It applies at a 40% rate. There are two main exemptions from the tax. The first is called the unlimited marital deduction. This is the ability that each of us has to leave unlimited amounts to our spouse at death, provided our spouse is a United States citizen. You can leave $5, you can leave $5 billion to your spouse, and there will be no federal estate tax. But the marital deduction is really only a deferral mechanism. Anything you leave to your spouse will be subject to tax at his or her later death. The only real forgiveness mechanism from the tax is called the applicable exclusion amount. This amount is roughly $12 million. It's indexed for inflation, so it'll go up a little bit each year. That's the amount each of us can leave to anybody, doesn't have to be a spouse, tax-free. Note that the exemption will go down from approximately $12 million to approximately $6 million on January 1st of 2026. While the federal estate tax is the most significant tax we're considering, some states do impose their own state-level estate taxes, including Connecticut at a 12% top rate, New York at a 16% top rate. Florida notably has no estate tax. The goal of good federal estate tax planning for a married couple is to try to use both spouses' applicable exclusion amounts or exemptions. And I think the best way to understand the planning is through two hypotheticals. In the hypotheticals, we'll assume a married couple with a $24 million estate. Both spouses are U.S. citizens, and to keep things simple, we'll assume the husband dies first in both cases. In the first hypothetical, we'll assume that the couple's entire $24 million estate is in the husband's name. He has a simple will leaving everything to his wife, and his wife has a simple will as well in which she says everything is left to the couple's children. What's the federal estate tax result? Well, we know that when husband passes that $24 million to his wife, it qualifies for the unlimited marital deduction. So there's zero federal estate tax at husband's death. But at wife's death, that full $24 million is included in her taxable estate. She has an applicable exclusion amount of $12 million to use against that $24 million, but the remaining $12 million is subject to tax at 40%. So there's a $4.8 million tax to pay before the children get their inheritance. That was entirely avoidable through planning shown in the second hypothetical. In the second hypothetical, we still have husband with the full $24 million estate in his name. But instead of having a simple will leaving everything to his wife, he breaks his estate up into two shares. Share number one is an amount equal to the husband's applicable exclusion amount of $12 million. Instead of that $12 million passing outright to his wife, instead he leaves it to a trust that we call an estate tax sheltered trust. Wife is given a lot of rights over that trust, but just short of enough rights to be called the owner of it for tax purposes. And the balance of the estate, which in my example happens to be another $12 million, passes outright to the wife. What's the tax result? Husband has died, wife is still alive, we've got these two buckets of money. Well, we know that the $12 million that passed outright to the wife qualifies for the unlimited marital deduction. So there's zero federal estate tax on that share at husband's death. What about the share passing to the estate tax sheltered trust? That's not passing to the wife, so it doesn't qualify for the marital deduction, but it's still sheltered from tax at husband's death because it's covered by his $12 million applicable exclusion amount. So there's zero federal estate tax at the husband's death, just like the simple plan we talked about in hypothetical 1. Where this somewhat more complicated plan changes things is when wife later dies. Her estate can only be taxed on what she owns. With the estate tax shelter trust, recall she was given a lot of rights, but not enough rights to be called the owner. So that trust is not included in her estate and passes to the couple's children free of tax. The other $12 million that the wife inherited outright from her husband is included in her estate, but she has her own applicable exclusion amount to use against it, so that share passes to the children free of tax. So that's a fairly long-winded way around to a simple point. By having this trust structure in their planning, the couple was able to shelter 2 federal estate tax exemptions from tax instead of only 1. In the previous slide, you heard me talk about the estate tax shelter trust, and I mentioned that that trust gives the surviving spouse a lot of rights over the trust, but not enough rights to be called the owner of the trust for tax purposes. Well, what does that mean? Well, typically the estate tax shelter trust can include the following terms without the surviving spouse being treated as the owner. First, it can provide that income and principal will be paid to the spouse for his or her maintenance in health, reasonable comfort, and support in his or her accustomed manner of living. Often the trust will also provide that the spouse is entitled to take 5% of the trust principal each year without regard to need, and that's in addition to what's available for their accustomed manner of living. The spouse is often given the power to appoint and remove trustees as well, and can even be the sole trustee. In the previous slide, you saw that the amount over and above the $11 million exemption passed outright to the surviving spouse. That needn't be the case. Some clients want to control what happens to the assets inherited by the spouse so that he or she cannot leave them to a new spouse at death. For those clients, the marital trust may be an appropriate vehicle. This is a trust for the benefit of the surviving spouse, but over which he or she does not have the power to give the money to a new spouse. When both spouses die, it's typical for the assets to pass into one or more trusts for descendants. For younger couples, a so-called family pot trust may be appropriate. This is a trust where the trustee has discretion to pay out income and principal among the family children for really any purpose and without regard to equality, sort of the way we assume most families would work while the children are young. For families with older children, we often provide that the trust assets at the death of the survivor pass into separate shares for each child, with each child having their own trust from which they may receive distributions for health, maintenance, and support. And often those trusts will say that at particular ages, the child may receive chunks of the money, a third at 30, a third at 35, all at 40, for example. Some clients want to protect the assets that their children inherit from the claims of a child's divorcing spouse or creditors. For those clients, the trust for descendants may be structured as so-called asset protection trusts. Traditionally, clients executed their estate plan through a will, a document that says, here's what happens to my assets at death. But wills are subject to the jurisdiction of the probate court. In effect, if you want to transfer assets under a will, your family or your executor has to get the permission of the probate court to do so. And that permission process can involve a lot of time, and because it involves a judge and court, it involves lawyers and legal fees. Some years ago, some clever lawyers came up with the idea of being able to transfer assets at death without the involvement of the probate court. The probate court really is only involved in the transmission of assets that were in your name at the time you died. The use of a revocable trust allows you to have no assets in your name at death, therefore no need for the probate court. How does it work? A revocable trust is a 3-part document. Part 1 says, I now transfer all my assets into my revocable trust, and while I'm alive and competent, I retain the right to do virtually anything I want with these assets. I can put them in the trust, I can take them out. I can amend the trust, I can revoke the trust. Part 2 says if I become incapacitated, as determined by the terms of the trust instrument, not by a court, then a second trustee comes in to manage the assets for me. Part 3 is the part that avoids probate at death, and that's the part of the trust that says, here's what happens to my assets when I die. So all these things that I've talked about before as being done under a will, like the estate tax sheltered trust and the trust for descendants, are instead done under this master trust agreement, which allows the transfer of assets without the involvement of the probate court. An extremely important footnote: the trust only works if you've got assets into it before you die. So after you sign a revocable trust, there's a lot of homework to do, changing the titles to your assets to the name of your revocable trust. And that's something that you'll talk about with your Wigan attorney during the process of doing the estate planning. Functions of the revocable trust beyond avoiding probate are management of assets in event of incapacity, as I mentioned, and also privacy. A will technically is a public document. It gets filed in the probate court. That's not the case with a revocable trust, and for some clients that may be an important factor as well. One of the most important decisions in the estate planning process, and one of the most difficult, is going to be to decide who wears all the hats. Who will be the executor? Who will be the trustee? Who will be the guardian? The executor is someone who has a temporary job. It lasts about 18 months after your death, and that person essentially shepherds the estate through the settlement process. They hire lawyers and accountants to handle that. So it should be someone bright, responsible, and detail-oriented. Often it's your spouse to start with. It may be a child or children, but you needn't think that you have to appoint children as executors. It's not an honor to be appointed as executor. It's a heavy responsibility, so you should pick the person who's best for the job. Guardian is probably self-explanatory. This is the person who takes charge of minor children at the time of death. The trustee has a very difficult job in most cases because the trustee has to have 3 different qualities. They have to have the ability to invest the trust prudently, the ability to distribute it fairly, and the ability to administer it diligently. Those are 3 qualities that may not be present in any one individual. So you may find that you're appointing several trustees, one who may be good at the investment function, another who may know your children very well and therefore would be good at the distribution function, and you may have yet a 3rd trustee who's in charge of keeping books and records, who's particularly good at administration functions. This is a subject that you'll need to spend a lot of time on for most clients, and one on which your Wigan attorney can provide some guidance as well. We've talked a lot about death and taxes up to now. Let's close out by talking about another pleasant subject, incapacity. Should you become incapacitated and have no planning in place, your family would have to go to court to have a court-appointed guardian handle your financial and personal affairs, and that's something most people will want to avoid, and it's relatively easy to avoid. For financial decisions, you'll want to have a power of attorney in place. Typically, you would name your spouse as attorney-in-fact, with some trusted individual as successor to your spouse. You'll also want to think about having an advance medical directive. This is a document that appoints someone to make your healthcare decisions should you become incapacitated. The healthcare directive also talks about end-of-life decision-making, expresses your wishes around the withholding or removal of extraordinary measures should you be in a terminal condition. Thanks for listening today. We look forward to helping you out with your estate plan. If you have questions, please don't hesitate to contact me. My contact information is shown on the slide. Thanks again.